Welcome to today's webinar, Why Good Enough Isn't Enough, a fleet liability discussion presented by Automotive Fleet Magazine and sponsored by Supervision. I'm Chris Wolski with Automotive Fleet Magazine, and I'll be your moderator for today's event. I encourage you to ask questions during the webinar at any point, and we'll try to address them all. However, if we do not get to yours, don't worry. You will be contacted via email with a response after the event. Joining me today is Rob Mosley, transportation attorney at Smith, Moore, Leatherwood, LP. Rob is the head of the firm's transportation industry group, representing trucking companies, brokers, and logistics companies and their insurance carriers, with disputes involving commercial transportation accidents, federal and state safety regulations, commercial insurance coverage disputes, freight claims, and other disputes involving trucking companies. He has tried over 80 cases to jury verdict in federal and state courts of unlimited jurisdiction. And Rob serves as national counsel or quarterback for several insurance companies and regional and national motor carriers, managing active litigation in 20 to 30 states at any given time. So welcome, Rob.
Hey there, thank you.
Let's talk about, so we're talking about liability today and the threat of liability, and many fleets are facing the threat of significant liability judgments and payments, but they don't even know it. So how worried does the average fleet really need to be about liability?
That's a great question. Since 2011, it's like somebody flipped a light switch, and every other month on average, since 2011, there's been a verdict of over $10 million against a commercial trucking company. So it's a real issue, and as you can see by insurers leaving the market, not wanting to insure truckers anymore, it is a real cost of doing business today. Right,
sure. And as our next slide shows here, there is a lot of more cost for on-the-job costs as opposed to off-the-job costs. It's about 15 times more. And why are these costs so different? Is it the deep pockets theory of liability that a lot of fleets face?
Oh, absolutely. The deep pocket has a lot to do with it. It's also lawyer advertising. If you've ever got a TV on during the day, that's when people who've been in an on-the-job accident are watching TV, and there's no shortage of attempts to reach out to them and get them to sign on to a lawsuit or a workers' comp claim or something like that. And it happens all the time. It's not a rare occurrence that I'll take somebody's deposition and they were in one liability or work-related accident, and they were in a couple of accidents in their personal vehicle, and they've never gotten hurt, where it was their fault or whether they were in a personal vehicle, but the injuries are all related to the accident that occurred when they were either on the job or when it was somebody else's fault. So those are the things that tend to really cause the injuries.
Right. And talking about injury now, injury accidents, bent metal accident, we know is pretty more reasonable in terms of cost. It's just the damage to property. But when you add an injury or fatality on top of liability, as the slide shows here from our research with NETS, it's $38,000 on top of average cost. And why are you, how common is it for fleets to be found liable for an accident? I mean, is this something that they, if you're in an accident, are you going to be found liable no matter what?
Well, I think it's my theory of representing commercial trucking companies is that you get to explain a couple of things, and then after you've explained a couple of things, the jury tunes you out and quits listening to you.
Right.
And so the idea is even if it looks like a pretty defensible case, if you've got a witness that said your light was green, for example, then or the other person pulls out in front of you, the things that you have to explain can take away your credibility on the big issues. And so having to explain things as to why you didn't do this or didn't do that erodes your credibility in front of a jury and keeps you from being able to really have a clean trial on the merits. You get so bogged down in the details of what you're having to explain that the jury quits listening to you. And so
right.
even cases that are very defensible and that look like winners from a defense standpoint turn into cases that you run the risk of losing with a jury or you've got to pay something to make it go away.
Right. Right. Well, and we talked about really high judgments, and we have an example here of a $22.7 million judgment against a fleet. And you talked about earlier about it's becoming more common for these really high verdicts. Is this a trend? I mean, are we seeing these verdicts just cascading up, or is this something like a $22 million, or in some of these $10 million cases that you talked about earlier? Are those just outliers?
I think they used to be outliers, and now I think they've happened so often that maybe they're more the norm now. I think that there's a lot of factors that contribute to that, including one is the fact that the plaintiff lawyers that are suing the commercial vehicles are working harder, and they're sharing their data, and if you get sued by one lawyer this year, that lawyer, somebody sues you next year, they're gonna know what that first lawyer dug up on you. Because right. They're sharing that information, and there's so much public data out there on commercial vehicles these days that there's just a lot of stuff that can be thrown against the wall to see what sticks. And so I also think that jurors probably have a better I don't think jurors understand what $1 million really is, but they've been deluded by these ads on buying lottery tickets for $200 million and sports salaries being millions and millions of dollars. And I think that the concept of $1 million has lost its awe with jurors, yeah. And so $1 million just isn't anything anymore.
Right. And we've talked about the money that's involved with liability, but there's some other long-term effects in terms of backlash, bad publicity, increased insurance rates. I'm sure you've dealt with that in your practice, and then just the difficulty of recruiting drivers. Who wants to be working for a fleet that has a reputation that may have a reputation for accidents and liability, in particular if the drivers have been sued. So what about these long-term effects? Are these again, is this something that fleets need to also think about too? It's bad enough you have to pay out of pocket, but there are these kind of long-term, say, bad publicity or bad perception from the public and drivers, et cetera.
Well, I think you're absolutely right. There's a lot of collateral damage to an accident. You do get the bad publicity. You get the picture in the newspaper with your vehicle's logo on it, and people are looking at you. You get the increased scrutiny from the regulators, from the FMCSA or whoever might regulate your particular business. They're going to pay more attention to you. One thing, the slide set talks about difficulty recruiting drivers. Well, if your ISS score is so bad that every time you go by a weigh station you're going to get inspected, then drivers are going to understand that means they make less money. And so right. the folks like that are going to, if you're if your ISS score is high, you're going to get scrutiny, and you're going to have a hard time keeping drivers. And so it really all adds up to what I call safety credibility. And you've got to have safety credibility in order to negotiate with the underwriters trying to get your insurance rate set. Obviously, if there are if there are underwriters who don't want to write you, then you're not going to be in a competitive environment for your renewals, and so that means you pay a lot more for insurance. So all of those add together show you what the cost of an accident really is.
Right. Okay. So we talked about some legal terms here, and two of the biggies for us is liability, but there are a couple of different kinds of liability. There's direct liability and vicarious liability. Could you just kind of describe for us lay people on the webinar here what the difference between direct liability and vicarious liability are?
Sure. Direct liability is such as the driver running a red light or something like that. The driver has direct liability because he acted directly to cause an accident. Vicarious liability is the employer's liability for employing that driver who committed a tortious or negligent act. But a motor carrier or a commercial vehicle operator could also have direct liability in something like failing to maintain a vehicle, for example. Let's say they sent the driver out with a vehicle that had brakes out of adjustment or something like that. That would be a direct claim as well. So that's the difference between the direct and vicarious claims.
Okay, great. And then the other thing we'll be talking about in a couple minutes with some of our case studies is negligence. And there are a couple of different kinds of broad categories of negligence. You're going to take us through some. You're going to drill down into these a little bit more in a few minutes. But if you could just kind of describe what negligent entrustment and negligent retention are, the two broad categories, what they involve, and then we can drill down into those case studies in a couple of minutes.
Absolutely. Referencing back to the last slide, we were talking about direct negligence and vicarious liability. Well, the direct negligence, just like leaving the brakes unadjusted, involve things like negligent entrustment, negligent retention, negligent supervision, negligent hiring, those types of things. So what these involve is that the company didn't do all it could or what it should have done to make sure that it had qualified drivers in their trucks. And whether that meant you had a duty to train for a particular driving situation, or whether this was a driver that should have never been put in a truck, or whether the driver did things after he was employed with you, after he or she was employed with you, that should have alerted you to the fact that this driver is a problem and shouldn't continue to be involved with your fleet. And so those are the kinds of things that come up in these types of cases. In fact, a couple of lawyers in our firm are actually trying a case right now, and we expect to get a jury verdict back today in a case that involves just those issues. The plaintiff has made arguments that the company shouldn't have hired a particular driver. So it doesn't get any more real life than today, right?
Right. Sure. Absolutely. So let's. This is a nice segue. Let's look at 3 real-world case studies involving examples of fleet crashes and liability and all those different kinds of negligence that we've just been talking about. So if you could just take us through this, Rob. And our first case has to do with an unlicensed truck driver. So there's the basic facts there, but if you could just take us through this case, I'm sure the audience will be really interested.
Sure, absolutely. Well, this case involved a woman who was killed as a pedestrian by the moving truck, and the issue here was that the driver didn't have a commercial driver's license and wasn't permitted legally to operate the vehicle that he was moving, and so the beneficiaries of the elderly lady's estate filed a lawsuit to recover for her death.
Right. And here, as we have on the slide, they settled for $825,000. Now, there are a few issues that came up with this, and there are several liability factors, including negligent hiring, training, supervision, and entrustment. So why don't you walk us through each of these and why these were part of the liability factors for this incident?
Sure. The negligent hiring is the concept that you didn't do what you should have done before you retained this driver. So you didn't do the right background checks. You didn't see what was either before you or should have been before you in terms of the job you were asking this particular person to do. Negligent training has to do with what happens after the hiring. So it's typically that the issue of you didn't train the employee to encounter the situations that they should reasonably be expected to encounter. So, for example, if the argument would be that you didn't train the driver to drive in snow when the driver's going to be driving in an area that is reasonably expected to have snow, or if you didn't train the driver to drive in heavy downtown New York City traffic when that driver was expected to go in that location. Supervision is generally what happens after the hiring is that the person was doing things inappropriately or doing things that the person shouldn't have been doing, such as accumulating traffic citations or having their license suspended or something like that. And obviously in this particular example we're talking about, the guy didn't have a CDL. So if the CDL suspended, if the CDL whether it's for library fines, child support, or traffic violations, that's something that the employer, the motor carrier, needs to know about. And then finally, the negligent entrustment involves the provision of a 80,000-pound truck to the particular driver. So all of those kind of work together. Now, in some states, they're different in how they treat those different factors, those different causes of action. Some of them are you can possibly make it easier on yourself by admitting that the person was in scope and course of their employment, but the minority of states will allow all four of these to go forward independently, and it's very harmful. It's very harmful evidence when they're allowed to get into. I mean, if you think about it in terms of a bullseye, the center of the bullseye would be the scope of admissible evidence in terms of who ran the red light type case. The guy who was standing on the corner says this person ran the red light. The doctor says the person in the car has a broken leg. These are their medical expenses and things of that nature. So that part of the bullseye is pretty narrow. But once you get into these other cases or the other causes of action, you really blow out the scope of the admissible evidence, because if you're saying that you shouldn't have hired the driver, then the scope broadens to talk about what the company knew about the driver, and that stuff would never be admissible if the suit was only against the driver. But when they bring in all the other stuff about what a nasty person this driver is, that really can inflame juries and make things difficult. And then beyond that, let's say that you're a motor carrier and you're your shipper or your broker gets sued too, then they're going to try to bring in all the evidence about why you're a bad trucking company because you didn't do the right checks and you didn't do the right things you should have done in order to justify their business. So it can really get broad once it gets beyond just what the driver do that day.
Right, and that's common then. So this, you're having numerous factors involved in broadening. That is something to be expected then if you're facing a liability case.
Well, we're seeing more and more of that because of the a lot of trucking companies still only have the $1 million in minimum insurance, and when you have that minimum insurance, it makes the plaintiffs in a serious case, in a tragic or catastrophic case, it makes them look a lot harder for the money, and so that's when your customers and brokers and other folks start getting brought into the lawsuit.
Right. Okay. Great. So for our next case, we're going to be talking about the dangers of self-reporting. So this is something I think a lot of us are familiar with. So walk us through this and what this case was about. And we'll talk about some of the dangers of self-reporting.
Sure. Okay, so we've got a collision between a pickup and a commercial vehicle, or the company-owned pickup. This is not a 26,000-pound truck, but nevertheless, a company-owned vehicle that is certainly a liability-creating asset. And so there was an accident. The driver of the pickup truck had a license that had been suspended for 5 months at the time of the accident. He was on his cell phone. Argument was that he was distracted, and then the jury awarded $3.6 million because they didn't accept the company's position that they had a company policy to report violations. You can understand why there's an inherent conflict between the employee's duty to report a loss of a license or a vehicle infraction that might result in a suspension or something like that, and the employee's self-interest in keeping a job and supporting their family and that sort of thing. So, a policy to self-report with nothing more is going to be a problem. And so, and keeping in mind that there are no regulatory requirements to do an annual MVR check on a driver of a pickup truck like there are on the over 26,000 pounds, over 10,000 pound vehicles, other commercial vehicles. So there's no regulation at all. And so essentially, this company was sending the driver out there without a driver's license. As a side note here, I'll mention to you that a lot of times an employee, one problem with a self-reporting requirement is that the employee may not even know their license has been suspended.
Wow.
For example, if you get a ticket in another state and you don't pay the ticket or something like that, there are so many layers of bureaucracy in a DMV type environment, and so that was why they created the CDLIS, the Commercial Driver's License, CDLIS. The CDLIS is a system that's supposed to be a uniform reporting system, but it doesn't always work. And so if I, in some states you don't pay a library fine, eventually it gets to the point where they suspend your license, and maybe you don't live there anymore, and you don't get the notice, and you don't even know that your license has been suspended. You don't pay child support, your license gets suspended. You're a student in some states, and you don't do the required things that students have to do, stay in school or whatever. You may lose a provisional driver's license. There's a lot of things that just are out there that might where you actually might have a legitimate statement that I didn't know my driver's license had been suspended.
Right.
I thought that had been taken care of. Those kinds of things. And so so self-reporting, not only does the employee not really want to tell you about it, but the employee might not even know.
Right. Right. And this case, it's interesting. What I think is interesting about this case study for our discussion is the driver and the employer or the fleet was sued for the liability in this accident. How common is that? I mean, is it basically standard operating procedure? You sue the driver and you sue the company at the same time, or is this an unusual case in this situation because of the vicarious liability and some of the other issues we talked about earlier?
Right. Well, it happens every day. It's very rare. In fact, it's very rare to see a driver sued without suing the employer as well. On most accident reports in across the country, which is what the plaintiff's lawyer is going to make a complaint based on, it's going to tell who's the driver of the vehicle, but it's also going to tell who the owner of the vehicle is. And so the owner almost always gets sued along with the driver of the vehicle. Now, the owner may not necessarily be the employer, because the vehicles may be leased or something like that. But eventually they'll figure out who it was. And there's also, for commercial vehicles, there's a mandatory commercial vehicle supplement that has to be filled out by state law enforcement, that if one of the vehicles is a commercial vehicle, it has to give the DOT number and the motor carrier or the operator of that vehicle. So with the supplement, you'll always get the name of whoever's DOT number is on the side of the truck. So that person will certainly get sued. That company will certainly get sued in this situation. Right.
And I just want to drill down a little bit more in the defense. The company's defense was that they had a policy, the self-reporting policy in place. And so, a lot of companies, a lot of fleets, they have policies of all sorts. And, the argument could be made that we have this policy, we expect the driver or the employee, whatever the situation is, to follow this. It's in a handbook, it's in something they acknowledged, et cetera. Walk through something about, it's not just enough that just have a policy in place. You have to do something in order either to enforce it or make it part of that driver or employee's behavior, right?
Absolutely. I mean, here the voluntary reporting policy did not result in compliance,
right.
And just from a jury dynamic, everybody's got a truck driver or somebody in their family that drives a commercial vehicle. And generally speaking, juries actually like truck drivers, and they kind of they'll give a truck driver a break. But when the evidence of negligence goes to the management of a company that owns a fleet, that becomes a bigger issue. That becomes a bigger problem, and so that's why these negligent entrustment, negligent supervision, retention type arguments get so much traction from the plaintiffs.
Right. Okay. And now on to our final case study, and this one is about a driver who drove with a suspended license and multiple violations. If you could just walk us through the facts of this case. Sure. So you've got somebody driving a pickup truck when they got hit by a commercial vehicle. There were some serious injuries in the accident, and of course keep in mind that if you look at the inflation rate for what healthcare costs have done, it's not hard to figure out why these jury verdicts are going way up, because our healthcare costs so much more, and some states allow
a person, a plaintiff, to put into evidence the amount of the bills that they receive from the hospital, even if the insurance company, their health insurer, writes off 70% of it, they still get to put 100% of it into evidence to talk about what their damages are. So there's some a good number of states that still allow that kind of thing without any reduction. So that's that's just a side note for you as to why these verdicts continue to escalate. But this particular accident involved a commercial truck driver with 21 traffic violations, including some speeding violations and a DUI. Now, he had a suspended license at the time of the accident, and this is different than, I didn't pay my library fines and that's why I got suspended. I mean, this guy clearly should not have been driving a commercial vehicle. But his license was suspended at the time of the accident, so he had no legal right to be driving the vehicle. Now, and so result is a $1.6 million settlement, and certainly that could have been a lot worse had it gone to trial and jury got gotten furious with a trucking company over putting somebody in a truck with that kind of history. It's one of the things that I'm surprised that somebody would have approved that driver to even operate a truck from an insurance underwriting standpoint. But that's what we see, and this is not unusual. Unusual in the sense that we expect our truck drivers not to have that number of infractions, but it's one of those things that if the company had known he had a suspended license, it may be that this type of whatever it was suspended for, it could have been fixed, and if he didn't have all the other issues, then maybe he could have been salvaged as a driver had you known about it sooner. And where it is now is, now you've got an accident with the guy with a suspended license. But if you had the opportunity to intervene before the accident, maybe you could have fixed some of those things, and you could, or at least you could have said, this can't be fixed. We can't have him on as a driver anymore. But a lot of license suspensions can be resolved. And quite frankly, I know this will surprise all of you, but the DMV makes mistakes, and so there's a lot of times there are infractions and things on somebody's driver's license that ought not to be there. And if you bring it to the driver's attention and say, hey, tell me about this, and he can say, well, that's my brother, or something like that, and you can figure out how to salvage a driver that you otherwise were going to lose.
Right. And in this case, unlike the previous one, in this case, the trucking company was really the target of this case, instead of the driver, who had a pretty horrible driving record. Talk us through why, in this case, they may have targeted the trucking company and maybe not as much the driver. I mean, is there a theory why they would have done that?
Oh, sure. There's a theory. The driver doesn't have any money.
Sure. Okay.
I meet with truck drivers every week talking about their cases, and I always tell them the same thing. I say, look, I've never seen anybody say they want a penny from a truck driver. They don't want any money from you. They want money from your employer or your insurance company. And so that's the reason why they want. In fact, a lot of times they'll actually make the driver out to be the victim.
Wow.
This company put you out on the road without training you how to do this or that. They put you out on the road knowing you didn't know how to do this, and they make the truck driver into the victim and make the trucking company into the center of all evil in the universe. Right.
And it goes back to what we talked about earlier with the deep pockets theory of liability. The plea has
Absolutely.
money and the deep pockets. Right. All right. Well, okay. Well, the fact now that we've walked through a lot of the negatives, let's walk through some positives. There is a solution to liability. I think most of our listeners probably know this. It's a strong fleet safety program that holds drivers accountable, and that will help to limit the fleet's liability. And one of the ways to do that is through continuous MVR monitoring. And while many fleets have continuous MVR monitoring, or MVR monitoring, they don't do it continuously. And continuous MVR monitoring is the bedrock that fleets need to underpin that safety program that limits liability. So, Rob, from your experience, you've been in front of a lot of juries and been involved with a lot of cases. Why are continuous MVR monitoring programs so important to limit liability?
Well, I think the sooner. Well, let's talk about the nature of a fleet operation today. And here we are in 2018, and what we see is that the owner of a fleet, or the operator of a fleet, is continually being pushed for the monitoring of the vehicles. I mean, let's think about it. 20 years ago, truck driver went out, over-the-road truck driver. We sent him out today. He came back 2 weeks from now. We had no idea what he had done. And then they came up with this thing called a tachograph. That if you've got enough gray hair, you might know what I'm talking about. But it was like I can remember when I was a kid, on the back of the cereal box, sometimes you could actually cut off a record to put on your record player and listen to it. And the tachograph was kind of like a little thin piece of plastic, like that record. And so I've immediately lost everybody on this call who's
no, I remember those.
who's under 40, but the tachograph would give you the speed of the truck, and that was the only thing, and that was like high tech back then, is you could figure out how fast was this driver driving. And today, with all of the advancements in technology, we have the GPS tracking. We know where the driver is. We know the speed of the truck. We know with video cameras and event recorders, we know we can actually see video as we sit at our desks trying to manage the fleet. We can see the video that's of what our driver's doing, almost in a real-time basis. And now with the collision avoidance, collision mitigation devices that are on the trucks, we're almost to the point of real-time managing a driver, and meaning that literally you could pull a driver off the road because the technology was telling you the driver was having a bad morning. And right. so I think that we're getting to the point where this data is available, and sure, the regs say you only have to do it once a year, but the regs are always interpreted as the minimum requirement, and who's to say that there won't be a case one day that says that you're held to a higher standard and you should have known better. And so continuing the continuing monitoring, and as I mentioned earlier, is that your biggest asset today isn't your trucks, it's your drivers. Everybody's right. Scrambling to get drivers. And you can take a driver who's on the margin and with some continuous monitoring from a license standpoint and from other standpoints. You can take that driver and you can coach that driver through his or her problems, and you can make them a good driver. You can use the technology that you have to transform a marginal or unacceptable driver into a good driver. And so you're able to do that and salvage that driver. So that's on the positive side of what you can do. But you also, and of course, there's the negative side. Is if we don't do this, and if we don't take these opportunities to try to make drivers better drivers or good drivers, we're gonna have to deal with the liability issues.
Right, and I think to put this into perspective, the benefits of continuous MVR monitoring. A monitoring program costs about $15 per driver. Now, we've talked a lot about $1 million jury judgments. $15 seems like a pretty That's a pretty good investment. And it also allows you, and I think you're just, this is kind of what you're touching on, it allows you to identify those risky drivers and maybe help them become and coach them to become good drivers, or in worst case scenarios, dismiss them before an incident happens. But one of the things I want to ask you, Rob, is, the reality, unfortunately, is that accidents are going to happen. No matter all the, the technology you're talking about and continuous MVR monitoring, et cetera, unfortunately, occasionally accidents do happen. Now, from your perspective, as a legal person who's tried cases, how can a fleet's legal team use continuous MVR monitoring to its advantage? Now, you said that a lot of times juries just stop listening. How do you get them to listen? How do you how do you use this to your advantage?
Well, I think not having continuous monitoring is something that you may have to explain. And so in this situation, let's say you're a motor carrier and you've got a duty to check the MVR once a year. Well, that means that you've got 11 months and 29 days, but between license checks, that something could go on that driver's record that you don't know about. And so it's kind of like the old Ford Pinto argument. The Ford got hit with huge verdicts because they didn't spend the $28 that it would take to put a separation between the fuel tank and the passenger compartment, and people were getting hurt, and they crushed Ford over that issue, and this is one of those things that you would have to argue. You may find yourself in a position arguing that it wasn't worth spending the $15 a day, the $15 per driver that it would have cost to give you a better system to monitor your drivers. And again, your jurors on a case like this are used. They're accustomed to having real-time information, and if they want to know what movie's playing at the movie theater, they pull their phone out and they find out what movie is playing. If they want to get the results of the baseball game, they pull their phone out and check it. And why you're going to wait for a year to get an MVR in is something that's really going to be hard for them to understand. If you could have learned something more in the intervening 11 months before you looked at that driving record, especially if it was somebody, if it's something serious, you just used up one of your things that you get to explain. So, very, very difficult situation. You don't want to use up one of your two. Again, that's just my theory. But you get to explain two things and they quit listening to you. So you don't want to use up one of them on something easy like this.
Okay. Well, great. Great, Rob. Thank you so much for taking us through all these case studies and one of the solutions to liability. And we do have some time for a number of questions, for some of our questions that have come in. We've had a few. And I'm going to go through those. And again, I want to remind everyone, if we don't get to your question, it will be answered after the event. So let's start with a question we received from a transport company manager. This company recently put in event recorders in their fleet, and wants to know if there have ever been cases that you've been involved with, Rob, that still went to court even with video evidence.
Sure, and again, the video evidence that just goes back to the real-time nature of what commercial vehicles are today. Is that there's an expectation that what's happening with those trucks at all times. Now, I love the video recorders. I love the event recorders. I'm a huge fan, and I don't care whether you have it frontwards and rearwards or not. But I think it's better to have it rearwards because I think that gives you another thing not to explain, because you don't have to show that the driver wasn't falling asleep because you got a video showing the driver wasn't falling asleep. But the video cameras are great, and the reason why they're great is this. this. The science says that 75% of all the accidents are caused by the passenger vehicle in a commercial vehicle accident. And so we're not winning 75% of the cases. And the reason we're not winning is because people aren't believing the driver. Their things are being gray because of accident reconstructionists come in and canceling each other out as to who says who's at fault and things of that nature. So I'm a big fan of the cameras. The only things I'll tell you is this, is that you got to watch them. You got to watch those videos. You got to coach. You got to coach those drivers and help them to be better drivers. Take the time to make that driver a better driver, and then finally, once you have coached and that video is no longer useful for managing the driver, that video needs to be deleted. There is no reason to keep that video. If you remember, in the old days of driver qualification files that were paper files, if you'd been with a company long enough, your file might be 3 or 4 inches thick. Well, what you would do is you got to get rid of that stuff, because you can easily make your best driver look like your worst driver if you're going to keep 37 warnings from the safety department because the driver didn't do something with his logs. Okay, so
right.
So you got to keep it while it's useful for management. Once you've managed the driver, you don't need it anymore. So make sure that you're using those correctly. But cases still go to trial with the videos. That doesn't make them go away. But I will tell you that there are a lot of cases that get dropped because the plaintiff's lawyer is sitting across the table from me looking at the video, and he says, "Ooh, I didn't know this. I don't think we'll be filing this lawsuit."
Right. Okay. So getting back to some of our, we talked a lot about high judgments. Here's a question: which states are more likely to award very high judgments?
Great question. I think that it's not really. I wouldn't look at it as a state issue as much as I would a local issue in terms of it's more regions than states. And now Louisiana's got kind of a bad reputation, just for example, of being a place where their verdicts are high, but typically big cities have larger verdicts than rural areas. Although that's not always the case, I would say that there are probably 2 or 3 counties in every state in the South where even though the people in the states are generally pretty conservative as jurors, there are always 3 or 4 counties in a given state where the verdicts are much higher. And so, but generally speaking, I would say that you see these areas of South Texas where verdicts are really high. New Mexico's got some places where verdicts are really high, but generally it's going to be places where the population is centered in a city, high density population, and those are going to be your more liberal venues from jury verdict standpoints.
Okay, and getting kind of following on to the video recording data that we just talked about. Can the data history, or maybe how can the data history from a company's telematics system be used against that company to show how dangerous the driving patterns were within that fleet during a case?
Another great question. Well, telematics, it's like my old football coach used to say, the eye don't lie. And so when the other team, threw a touchdown pass over me, there was nowhere I could hide. That was what the data was, and along those same lines, the data's there. And if you've got drivers that are hitting 2 and 3 hard breaks a day, that's something that somebody needs to be coaching. And I'll tell you that every time there's another piece of technology on a truck, there's more data. I went to a truck accident scene the other day, and there were like 7 different places on the truck that you could download data. from an ECM to ABS system to cameras to, it was just one after the other. Is you can just walk around the truck and say, here, I need to plug in here, I need to plug in there, I need to plug in there, and to get all the data. And so the data is out there, and if it's bad, you better believe it's going to be used against you, and that's why it's important that you take an active role with your drivers, with your commercial drivers, and make sure that they're doing the job the way you want them to do it, because you're getting the data. You can't stick your head in the sand and pretend like you didn't see it, because it's going to be there for the world to see and to hold against you if you haven't done anything about it. So coach those drivers, walk them through what happened, and explain to them why that's not acceptable, and then make a better driver out of the person. Right.
Yeah, and my experience, my understanding is with telematics data is that it basically exists forever, and it kind of goes back to what you were talking about at kind of the top of the webinar, that a lot of this is kind of public data, or if there's data that exists, the plaintiff's attorney is going to find it. I mean, that goes without saying, right?
Yeah, and Chris, that data shouldn't exist forever. I mean, it can, but it shouldn't. I mean, once it's no longer useful for training and management, it ought to disappear. And so if your company doesn't have a good data retention policy, that's probably a good next step for you to figure out how long you should keep the stuff. There are regulations that say how long you have to keep certain types of data, but a lot of it you get to decide how long you want to keep it.
Right. Okay. Here's a good question about just the variabilities that come up with drivers. Now, if a driver has passed his pre-hire drug screening and has had 3 random drug tests that he's also passed, then has an accident and tests positive, how much negligence really goes to the carrier? Well,
and with the drug testing, I'll tell you that this is your predicament as a commercial fleet operator, is that the DOT drug tests are woefully inadequate for actually catching people using illegal drugs. And what I mean by that is up to the first of the year, it didn't even include a lot of the synthetic opioids, and there's still a lot of synthetics that aren't being caught.
Right.
So they added 4 more categories of opioids to the DOT drug test, but we're still so far behind the technology for the drugs that are out there today. And so my estimate is that probably there's probably 40% of the drug use that's out there we're probably not catching with a DOT drug test. And so I'll say that first, and then I'll say this, is that when a driver is in a bad accident and the law enforcement takes that driver for a drug test, they don't give the driver a DOT drug test. They give the driver a 9-panel law enforcement drug test that is much more stringent and much more technologically sound in terms of what we're dealing with today in terms of drug use. And so your driver will very likely test positive for something that even if you'd have given the driver a DOT drug test the day before, it would have been negative. Your DOT drug test would have been negative, but law enforcement found something there. And so there's a lot of scenarios where that happens. Generally speaking, I would say that you're going to be not that you won't have some explaining to do, but if you've done what you're supposed to do in terms of drug testing and you didn't have any reason to know that there was a problem, in other words, the driver was interacting with law enforcement and they had no idea he was on drugs, and the driver was interacting with you the day before, when he's talking to dispatchers and hanging around the terminal, and you inspect, he came through for a truck inspection the week before, and nobody smelled anything funny in the truck, and so all of those things kind of play together. Certainly, if the driver was doing something that should have been a red flag to you, that's going to be an issue. But if you didn't have any reason to know, then the burden's going to be on them to try to show why you should have known this person was on drugs.
Right. Okay. All right. Well, here's a question that goes back to one of our case studies. What steps do you recommend to enforce a self-reporting policy effectively to reduce company liability?
Well, I mean, the reason why we have an annual MVR check for the commercial vehicles is because self-reporting by itself doesn't work. Now, when you have there's a couple of things going on, and it doesn't apply to all fleets, but if you've got a DOT number, then you essentially should be getting some real-time information. If you're checking your CSA once a month, you ought to be getting at least some of that. Now, a lot of it, the reporting processes are not perfect, and there's no guarantee that it's actually going to come through the way it ought to. So you can't rely on that, and that's why the DOT hasn't done away with MVRs. Is that you can't get it all from just what's out there on the CSA or the SMS system, and so you've got to. That's going to give you some information, but it's not going to be nearly as good as going out and running a full report and having a full report delivered to your inbox. But you've got to make sure that you're understanding what it is that could be out there that you don't know about, because you don't know what you don't know. And that's the danger of not having a system in place to tell you what's happening on the road.
Okay, well, great. And we've talked a lot about a number of cases that went to trial, including the example you gave of the one that your colleagues are handling today. But generally, what is the percent of cases that go to trial versus being settled?
I'll tell you that it used to be that probably 70% of cases settled and 30 went to trial. It's probably more like 95 and 5. But I'll also tell you that it's harder to get the 95% to settle today than it has ever been before. We used to do a mediation, and everybody would get together and try to get the case settled. And yesterday, I had a case that I was in the second mediation for because the first one didn't work. And so more and more, you're finding that cases don't settle at mediation. There's a second mediation. There's a third mediation. People want to hold on to their big dollars as long as they can, and so I think we're starting to actually see more cases get tried as we go further down the road. But part of that is that I think plaintiffs' lawyers are more willing to swing for the fence, and if you're offering them a fair settlement, they may say, "I don't want a fair settlement. I want an unfair settlement. I want a settlement that's worth more than my case is worth, or I'm just going to go swing for the fence and try to get the huge verdict from the jury. And if they come back and they only give me what you offered me, I'm still just as well off, and I took my shot." Right. So a lot of cases, still not many cases going to trial, but it's I'd say it's actually it's probably a more contentious litigation environment now than it has been in the past. Okay, and our final question: how do you get the message through to your fleet or company or ownership that you need to have proper risk management with your fleet? Well, I mean, certainly, all you've got to do is interview somebody that or talk to somebody who runs a commercial fleet that got hammered because they didn't realize they had blind spots in their safety program, and there's nothing like 2 years of heavy discovery to show you what the blind spots are in your safety program. And I've got fleets that are really good fleets that were doing 99% of the things they were supposed to be doing, and it's just that one thing that gets you in a case. And now they're even without accidents in 2016, everybody's insurance went up on average about 29%. Wow. And so that's because of just commercial vehicle risks across the board. Well, if you want to cut into trucking runs on a very small profit margin, and you see a lot of margins in the 4 or 5% range. That's not a lot of money to turn a profit into a loss if your insurance rates go up because of not just the industry, but also the if your loss rates are higher than the industry and you're having to pay a bunch of claims. Nothing can turn a 4% profit margin into a 4% loss.
Yeah, exactly. All right. Well, great. Thanks, Rob. That is all the time we have for today. But anyone who asked a question that wasn't answered, we'll be following up with you via email to answer your questions individually. Now, we hope that you enjoyed today's webinar and want again to thank Rob Mosley and Supervision for today's presentation. I also want to mention that this webinar will be available on demand on the Automotive Fleet website at automotivefleet.com/events. Thank you again to everyone who attended, and have a great day.